Today's date is November 19th, 2019, and the time is 10:39 a.m. We are on the record for the oral videotape deposition of Joe Gimenez.
Sir, could you please introduce yourself? Oh, sorry, you've got to swear the witness. That'd be good.
I swear or affirm the testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
I said I could multitask. I can't. Could you please introduce yourself for the ladies and gentlemen of the jury and say your name exactly the way you want me to say it, okay?
Okay. I'm Joe Gimenez.
Okay. And is it accurate that you are currently the president of the board of directors of the Windermere Oaks Water Supply Corporation?
Yes.
Okay. Are you aware that under the governing documents, the entity is required to operate as a cooperative? Do you know that?
No.
Okay. Do you know what a cooperative is?
No.
I'm going to call it a cooperative because that's how it's supposed to operate. So if I talk today about the cooperative, you'll understand that I'm talking about the water supply company, okay?
Checked form.
Will you understand that that's what I'm talking about?
Could you repeat the question?
Sure. And that happens, and that's one of the reasons why we give that little extra beat.
Okay.
So that you and I don't talk over one another, and so that if Mr. De La Fuente or any of the other lawyers have something that they need to say on the record, they get an opportunity to do that, all right?
Okay.
Okay. So for today's purposes, because the governing documents provide that the water supply company is to operate as a cooperative, I'm going to call it a cooperative. Will you understand today that when I say cooperative, I'm talking about the water supply company?
Checked form.
If I don't know what a cooperative is, then I don't know why I would have to I don't understand. I mean, I don't know how, if you're referring it to it in a way that I don't know.
I've got to call it something, and frog seems inappropriate, okay?
Is there another term?
For today's purposes, I'm going to call it the cooperative, and all I need to know from you is when you hear that word, will you understand that what I'm talking about is the Windermere Oaks Water Supply Company?
Checked form.
I don't refer to the corporation as a cooperative. I mean, it is a water supply corporation. So I've read the articles of incorporation, I've read the bylaws, so that my understanding, it's a corporation.
When I say the word cooperative today in this deposition, will you please understand that that means Windermere Oaks Water Supply Corporation?
Checked form.
Am I being compelled to respect that term?
You may refuse if you wish. I'll call it frog.
I'm gonna refuse.
Okay. And you're going to refuse because?
Because I have not read that word in our documents.
You haven't. Okay. Any other reason why you're refusing?
I haven't read that word in those documents.
That's the only reason you're refusing.
Checked form.
I haven't read those words in our documents. I mean, I just haven't read them. I know that that's what the petition claims, but I haven't read those words in our document.
So have you read the petition that I filed?
Yes, yes. The one that was filed last week, or?
The big long one that talks about cooperative, that's the one.
That's the one, yes.
You've read that one?
Yes.
Okay. When you read that and saw what it alleged about how this enterprise is supposed to be operated, did you go back and look at the governing documents?
No.
Has anyone ever advised you that the business is to be operated as a cooperative?
Object to form, and to the extent this inquires into any attorney-client privileged advice as to the nature of the entity, I'll caution the witness not to reveal the privileged information of the WSC.
And are you still calling it a cooperative? I'm sorry. So, no, I'm not going to.
We can read that question back.
Could
Would
you
that
read
be
that?
a help?
Could you do that?
Of course.
Has anyone ever advised you that the business is to be operated as a cooperative?
Same objection and cautioning instruction to the witness.
I'm going to listen to my attorney in this matter.
So, just so that I'm clear, are you telling us that you cannot answer that question without revealing the substance of communications between attorney and client?
I'm going to object to anything that would indicate the subject matter of attorney-client communications on behalf of the WSC, and instruct you not to answer.
Are you refusing to answer, sir?
Yes.
Why are you refusing to answer?
Under instruction of counsel.
Why are you refusing to answer?
And I'm going to instruct you not to answer the question to the extent that it would reveal the subject matter and substance of any attorney-client information.
Could you repeat the question?
Yes, sir. Let me explain something first.
Okay.
The court was going to look at this transcript later and decide whether your refusal to answer the question was warranted or it wasn't. Mm-hmm. All right?
Okay.
And so we need to understand exactly why it is you're refusing to answer.
Okay.
If you refuse to answer because you don't know, that's not something to be compelled. If you're refusing to answer for some other reason, that might be reviewable. I'm simply trying to make a record that a court could look at to determine whether or not you ought to have answered. Do you understand what I'm telling you?
Yes.
So I'm asking why it is you're refusing to answer.
Object to form. And the same instruction to the witness. Certainly, I think we're also remote in time to the question referenced, but I'm going to instruct the witness, again, not to reveal the substance of any attorney-client privileged communications regarding this subject matter on behalf of the WSC.
I'm going to listen to counsel and take their advice.
Okay.
You could, if you want to repeat the question one more time, please.
Has anyone ever advised you that the Windermere Oaks Water Supply Corporation is required to be run as a cooperative?
Same objection, same instruction.
I will listen to my attorney.
So is it fair for us to understand that if anyone has ever given that advice, it was only an attorney?
So the question is anyone.
Yes.
Okay. Could you repeat the question one more time?
Are you asking if anyone other than counsel legal counsel has ever given him that advice?
I'm really just asking whether anyone has advised you that the Windermere Oaks Water Supply Corporation is to be operated as a cooperative.
To the extent that that would encompass advice of counsel to the WSC, I'll instruct the witness not to answer.
Can you answer without revealing the substance of communications between you and an attorney for the water supply company?
Object to the question. There's no way to answer that without revealing the substance of the question, so I instruct the witness not to answer.
I'm listening to my counsel.
And refusing to answer?
Yes.
Okay. Any accountant ever advised you that the Windermere Oaks Water Supply Corporation is required to be operated as a cooperative?
An accountant? No.
Do you understand that the Windermere Oaks Water Supply Corporation claims a tax exemption under 501c12?
No.
You don't know that it's a tax exempt entity?
Check form.
Let me rephrase that because his objection is well taken. Is it correct to say that you don't know that it claims a tax exemption under 501c12?
I don't know the tax law I mean, I don't know how it's structured for the tax.
When the tax reporting documents are filed, is it your name that's on them these days?
It was this year, yes.
So your name is on a tax reporting document, but you don't know whether the entity for which you're signing is claiming a tax exemption or is it not. Is that right?
Check form.
I don't recall that document.
So you don't know whether the document that you signed is claiming tax exemption for the entity or not. Is that correct?
Check form.
I mean, do I have to answer that question?
You may answer a question if you can answer it.
I can't answer that question.
Okay. And you can't answer it because
Read the question again. What's the question?
she's going to tell you what it is.
Okay.
So your name is on a tax reporting document, but you don't know whether the entity for which you are signing is claiming a tax exemption or it's not. Is that right?
Check form.
I mean, I don't know. I haven't looked at those documents.
Wouldn't you agree with me that the board of directors has the responsibility for determining whether or not to file a tax information document claiming a tax exemption?
Check form.
I don't know.
If not the board, who would have that responsibility?
I don't know. I don't know.
Would you agree with me that the board of directors has the responsibility to make the required filings, tax filings, on an annual basis?
Yes.
Wouldn't you agree with me that the board has responsibility for making sure those filings are true and correct under penalty of perjury?
Check form.
I mean, I don't know.
If not the board, who would have that responsibility for the frog?
Check form.
I don't know. I don't know.
Do you not understand what the ramifications might be to the entity if it files a tax reporting document that is not true and correct?
Check form.
I don't know what that would be.
Whose responsibility is it, if not the board's, to make sure that the entity remains compliant with applicable law?
With applicable laws for what?
Everything.
Okay, could you repeat the question then?
Whose responsibility is it, if not the board's, to ensure that the entity remains compliant with applicable law?
I don't know.
Are you saying that you do not believe it is the board's responsibility, or that you do not know one way or the other, or something else?
Check form.
There are several questions in there, so I can't answer the multiple questions.
All right, well then we'll break them up. Do you believe it is the board of directors' responsibility to ensure that the entity remains compliant with applicable law?
Yes.
What steps, if any, has the board taken to ensure that the entity remains compliant with applicable law regarding its tax-exempt status?
Check form.
What steps, if any, we follow the advice of counsel?
Who prepares the tax returns for the entity?
I think this year it was Raven Heron CPA, an organization out of Horseshoe Bay.
Has Ms. Heron advised the board regarding the tax-exempt status of the entity?
No. No. I mean, she has not advised me.
And it's your name on the return, right?
Yes.
And just so we're clear, is it correct to say that you don't know one way or the other whether Windermere Oaks Water Supply Corporation is filing as a tax-exempt entity? Is that correct?
Object form.
So, say that again, please.
Do you know one way or the other whether the Windermere Oaks Water Supply Corporation reported itself on the return that has your name on it as a tax-exempt entity?
Object form.
I don't know. I don't know. I haven't looked at those documents
Okay.
in a while, so I don't know.
We got off on a bit of a tangent. I want to back up just for a second and tell you a couple of things about the deposition process. First, have you ever had your deposition taken before?
No.
You understand that it is a process by which the court reporter is going to take down everything that everyone here says during the course of the deposition. Do you understand that?
Okay.
And so you understand why it's important that we not be talking at the same time. She can't take down words on top of one another. You understand, right?
Right.
Okay. And also, as we discussed, if you just give it a beat, it allows any other attorney in the room to make whatever comment they'd like to make. Fair enough?
Got it.
People tell me that I'm very direct, but I find that sometimes in a deposition my questions are not quite as clear as I'd like them to be. But it's very important that you and I are communicating today. If I ask you a question that doesn't make sense to you, or you don't understand, will you let me know right then instead of trying to struggle through it?
Yes.
Okay. Because I might do that. If it seems to me that you're getting a little off topic from what I asked you, that you're not being too responsive, will you understand that I'm going to follow up on that to make sure that you've understood the question that I've asked?
I understand that.
You do understand that your most important duty as a witness here today is to tell the truth, right?
Yes.
And as long as Mr. De La Fuente does not put us on the clock too much, I'm going to let you say anything you want. You just tell me that there's something more that you need to say that I didn't allow, and I'll give you that opportunity. Will you do that?
Sure.
Okay. You can take a break pretty much any time that you like, and I'll respect requests that you make. Here's an exception. The exception is if I've asked you a question, I'm going to want you to answer it before you go on break. I'm going to want you to finish that thought before we stop and take a break. Does that sound fair to you?
I understand, yes.
All right. This deposition is a little bit different from the norm because it's focused in scope. Do you know that?
Focused in scope. Okay.
There are some issues that are pending before the court having to do with jurisdiction and whether the court has jurisdiction. And really what we're here today to do is focus on facts that have to do with those issues. All right, do you understand that? Mm-hmm. The difference that makes is it might seem a little disjointed. We might not go through every single detail of everything that ever happened that has to do with this dispute, okay? That's why I'm telling you, if you feel there's something that you need to add to make your answer complete, all you've got to do is let me know. Will you do that?
Okay.
And it's also why I'm going to try to be as focused and direct as I can, but I don't want to shortcut anything. So if you feel like I'm shortcutting something, rushing you, or cutting you off, I want you to tell me right then, okay?
Okay.
Because I don't mean to do that. My goal here today is learn the facts that you know and to let you tell them pretty much how you want to tell them, okay?
Okay.
When did you become president of the board?
March 9th of this year.
March 9th, 2019?
Correct.
Go ahead and get that. And I take it that you probably have a real job, do you not?
Yes, I do.
What is your real job?
I am a sole proprietor. I perform public relations and marketing communications for clients.
Does your real job include any aspects of real property valuation?
No.
Does your real job include any aspects of real property marketing or advertising?
No. I will say that I'm just thinking, I had a client one time who was a real estate agent, but I don't think that applies to what you're asking.
In your real job, is it that you're teaching people how to promote themselves or showing them how to promote themselves? Is that what you do?
Yes, yeah.
So in your real job, you do know that somebody getting themselves out and promoting themselves to the applicable market, to the people they're trying to attract, that's the way to get business, right?
Object form.
So could you say that question one more time?
Sure. Isn't it so that in your real job, the conventional wisdom is that in order for people to attract customers, bidders for their services, what they need to do and should do is to get themselves out on the market?
Object form.
I have a hard time with many parts of that question because you're asking about conventional wisdom. I don't know what conventional wisdom is. You're asking about people doing things. It was a complicated question.
Oh, fair enough. You can't answer it.
I can't answer it.
I'm not going to ask you about conventional wisdom because you don't know that. Do people come and pay you money so that you can either teach them how or do for them to promote them so that they get exposure across the market that they're trying to reach?
Yes.
And why do people pay you money to get them exposure in the market that they want to reach?
Object form.
Repeat the question one more time.
Why is it that people come and pay you good money to help them get exposure in the market that they want to reach?
Object form.
I can't speak to their motives.
Do you believe that you provide a valuable service to them, to the people who come to you, to help them get exposure in the market that they want to reach?
There's several parts to that question. So I don't know. I mean, so the question is asked, I can't answer that question.
What's the problem with the question?
Well, there were multiple parts to it that, I don't necessarily understand each part of it. If you could simplify the question some.
Can you read it back?
Do you believe that you provide a valuable service to them, to the people who come to you, to help them get exposure in the market they want to reach?
Yes, I provide a valuable service.
The election this year was not the first time that you ran for the board of directors out at Windermere, is it?
Correct.
Have you been attentive to matters involving the frog? I'm going to call it that because you don't like cooperative. Have you been attentive to matters that involve the entity for a while now?
Check the form.
You can repeat the question one more time, I'm sorry. Attentive to, I'm sorry, my hang-up is attentive to matters.
Have you paid attention to what the water supply company's doing, and have you been doing that for a while?
Does that mean, have I been attending meetings? That's a very broad question. I mean, do I read the letters that are sent? Yes.
Okay, so you read the letters that the board sends out.
Correct.
How long have you been doing that?
Since I became a member of the, of the community. That was 2014.
Okay, so you moved into the community in 2014?
Yes.
And you don't need to be specific with me, but in what general area of the community do you live?
On Coventry Road. That would be on the northeast side of the community.
Are you one of these airplane people? Are you one of these pilot people that have hangars out there at the Spicewood Airport?
No.
Have you ever been a part of that, what I'm going to call the airport community?
In what capacity do you mean?
Any capacity.
That's a pretty broad question. No, I mean, I don't know the definition of being part of the community. Have I gone to a party here and there that they've had? Yeah, I've gone to a couple parties that are open to the public. I don't know what you mean by, community. It's broad. I don't know how to answer that beyond what I've just said.
Okay, fair enough.
Yeah.
So, since 2014, you've read the letters that the board has distributed, is that right?
Yes.
Have you attended meetings? Board meetings.
In what year?
Since 2014.
Since 2014? Boy, that's a tough one. I mean, I've obviously attended all this year, or all since March 9th. But beyond that, in previous years, I attended a petition hearing in 2017. I can't remember. I attended one for a brief period of time, and I can't remember if that was in 17 or 18. But I mean, I can't remember if if it was more than one. It wasn't that many. If it was.
What prompted you to run for a directorship? Was it 2014 that you did that? I can't remember.
No, it was not 2014.
What year was it?
I ran, my first ran in 2018.
Okay.
And then 2019.
And so what prompted you to run in 2018?
What prompted me to run in 2018? I don't recall exactly what prompted me. I can say that I am a member of the POA board, the Property Owners Association board in our community, and I saw a lot of things in the Property Owners Association that needed to be done in terms of maintenance of our community assets, and I thought that probably some of this is coming back to me as I talk, so I remember when I stood up, and I think what I said on my form, I can't remember exactly, but I know when I stood up and talked at the 2018 annual meeting, I reminded everybody that I had worked on the POA to conduct a reserve study, which catalogs all your community assets, and it puts you on a schedule for repairing or replacing or maintaining community assets. And I think in 2018, when I first ran for the Water Corporation Board, I said to everybody that I wanted to do, a similar, give similar assistance to the Water Corporation. And I said that in 2018 and also in 2019 when I stood up at the annual meeting. And that's primarily the reason why I have run for these boards.
What investigation, if any, did you do to determine whether that kind of work, the work you're describing, the study that you're describing, was needed at that time?
On the POA, I could look around, I could see that there were literally, there's a pergola that you would touch and it would wobble and would fall down. There were basketball goals that needed painting. I found out that our electrical equipment was indoor rated, even though it was outdoors at things. I found out in the POA that our signage for our pools was non-existent and out of compliance with state and local regulations. I discovered that we had a fence around one pool that was non-compliant with regulations as well as the POA board. So what I saw around me was, and that's just some of it. I mean, I could go on because I saw there were issues with roads, with our tennis courts, a wide range of problems that needed to be addressed. So based on that assessment on the POA, I surmise, I guess is the best way to put it, that more attention needed to be focused on, could be focused by the Water Corporation on its assets and its equipment for, for keeping things running into longevity, over the long term for our community.
Did you make any investigation into the state of the assets that were used to provide water and sewer service?
In what time frame?
When you first were prompted to run for a directorship, which I think you said was 2018.
At that time, no. I mean, I didn't go to the water plant. I didn't, do things like that. I mean, I thought that was, would have been beyond what I needed to do. I mean, my exposure to the water plant was that there's a wooden fence that's not in very good condition. So.
Okay. When did you first hear about the dispute that brings us here today?
Take the form.
There are a lot of disputes, so you would have to be more specific.
When did you first hear about the board of directors transferring hangar lot property to a sitting director, and the allegation was that it was for far less than fair market value?
There's a lot in that question, and I don't know. I can't answer that because there's a lot of specifics that that don't jive with.
You're aware, sure. And if I interrupted you, you just stop me right now and I'll let you finish. You need to finish?
No, I don't.
Okay.
I'm sorry.
You're aware that the board of directors for Windermere Oaks transferred hangar lot property to sitting director or her affiliate in 2016, correct?
Objection form.
Sorry, what was that?
So if I have a problem with a term that you're using, I mean, I don't know that I can't answer the question that you asked.
What
with
term
one of
is
the
it?
term.
Sure,
Transferred.
Just transfer?
Yes.
Is it you don't know what transfer means?
Check the form.
How about deeded? If I use the word deeded, would that be better?
Deeded, transferred, those are words that are beyond what I know to be. I mean, I don't know the exact definition of those words.
So let's just say on day one, the real estate is owned and used as part of the facilities that are operating the water and wastewater service, okay? And on day 5, part of that real estate is owned by someone else. Are you with me?
Keyword there is owned.
Are you with me?
Yes.
What is it that you use to describe how that happened?
I would use the word sold.
Sold. Okay. Let me try it then. You are aware, are you not, that the board of directors in 2016 sold hangar lot property to a sitting director on the board, correct?
Objection form.
Check the form.
Could you repeat the question?
Are you aware that in 2016 the board of directors sold, to use your word, hangar lot property to a sitting director or her affiliate?
Objection form.
Check the form.
I mean, I am aware, yes.
Okay. And you're aware that the plaintiffs in this lawsuit allege that the sale was made for much less than fair market value of the property, correct?
So you're asking me if I'm aware that they allege that?
Right.
I am aware that they allege that, yes.
And I'm taking it that the board does not admit that. Is that accurate?
Check the form.
Does the board, let me just ask you, does the board admit that in 2016 hangar lot property was conveyed to a sitting director or her affiliate for far less than fair market value?
I'm sorry, you'll have to read, there's a lot in that question, so you'll have to repeat that for me. Could you repeat that for me?
She'll read it back, sure.
Let me ask you, does the board admit that in 2016, hangar lot property was conveyed to a sitting director or her affiliate for far less than fair market value?
Check the form.
The board does not admit that.
Okay. So there's a controversy about that. Is that right?
Yes, there's controversy.
Okay.
Well, hold on. About what exactly?
About whether or not the board of directors sold, to use your word, sold hangar lot property to a sitting director or her affiliate for far less than fair market value. Is there a controversy about that?
Yes, there's controversy about that.
Okay. Let me show you what I've marked as Exhibit 1 to the deposition. You'll have to reach a little bit because I'm way over here, and I apologize for that. And please do share it with Mr. De La Fuente. I'm going to hand you some documents during the course of this, and you just read them all you need to, okay?
Okay. Okay.
Do you recognize Exhibit 1?
Yes.
When did you first see it?
Earlier this year. I mean, specifically, I don't know.
Was it before or after you became a member of the board?
I can't recall that. I don't.
Can you recall the circumstances?
No. I can't recall if I saw it before or after, or, I mean, it's not ringing a bell with me if I saw it before I ran for the board. And then if I saw it, I can't tell you when I saw it afterwards. I'm sure I saw it afterwards.
Okay. It's a letter prepared by Mr. De La Fuente, who is the gentleman here with you at the deposition today. Is that right?
Yes.
And he was then and today with the firm Lloyd Gosselink. Is that correct?
Yes.
Was the firm Lloyd Gosselink in January 2019 engaged by the board to represent the water supply company?
From the appearances of the letter, yes.
Do you think otherwise?
No. So I'm not familiar. The board had different counsel at one point, but I'm not sure when that counsel, when Lloyd Gosselink came on or what have you. But from what I know, there's been three attorneys for the water company in the last several years. But that's...
You're on a litigation subcommittee of some kind that you established, isn't that right?
Legal subcommittee, yes, ma'am.
Legal subcommittee. And part of what your job is on that legal subcommittee is to keep track of litigation, right?
Yes, ma'am.
Have you performed your job? Have you done it?
Yes, ma'am.
Did you undertake to learn what had happened before you came on the board?
Check form.
Mr. De La Fuente's right. You do know that litigation has been pending concerning the sale, to use your word, of these hangar lot properties for a while, right?
Yes, all members of our community are aware.
Okay. When you came on the board and became a member of the legal subcommittee, did you undertake to educate yourself about what had happened in the litigation before you came on the board?
Yes.
Was it in connection with that investigation that you first saw Exhibit 1?
Possibly. I mean, probably. I mean, like I said earlier, I don't remember exactly when I read this letter.
Is it fair to say that, so far as you're aware, the Lloyd Gosselink firm was the water supply company's attorney at the time this letter was written in January of 2019?
Yes.
And Mr. De La Fuente over there is the same guy who's sitting with you today, who wrote this letter. Is that right?
Yes.
And this letter says, and I'll direct you to page 3, but after we are done with that, you look at any part you want.
Okay.
And at the bottom of page 3, in the last paragraph, it says these words: the WOWSC board, at the very least, sold property with a proper market value of $700,000 for a price of $203,000, comma, a difference of $497,000. Correct?
Yes, that's what it says.
Have the attorneys for the entity ever changed their opinion?
Object to form and object to the extent they are seeking any attorney-client communication regarding this subject matter, and instruct the witness not to answer.
Objection 4.
Just for the record, you're just going to have to say, I'm not going to answer that.
Okay. I'm not going to answer that.
Okay. And again, just for the record, is it fair for me to understand that you're not going to answer that under a claim of privilege?
Yes, on the advice of counsel, yes.
Okay. You understand? I'm just
I
got to
understand.
make my record. When you investigated what had gone on in the litigation, did you learn that there was a time that the board voted to proceed with all available avenues of recovery against Martin and Friendship, and maybe even the appraiser Hinton? Did you learn that?
No.
Are you aware of that now?
Object to form.
I'm not aware of that now.
Can you envision?
I mean, I am a bit, after you told me, if that's true, I'm aware now, but I wasn't aware.
Can, as a member of the current board of directors, can you envision any circumstance under which the board's sale of property with a market value of $700,000 for a price of $203,000, comma, a difference of $497,000, could be fair and in the best interests of the enterprise?
Object to form.
Object form.
That's a hypothetical question. As a matter of form, I don't answer hypothetical questions. That's
It's the opinion that your lawyer gave in this letter of January 2019, Exhibit 1. Isn't that right?
Object to
Objection
form.
4.
No, you asked a different question a minute ago.
Do you see that the opinion that your lawyer gave in the January 2019 letter, I can read it again if you want, but if you can look with me
It
at
wasn't
page
that
3.
question that you asked. I'm sorry.
I'm asking a whole different question.
Okay.
So we can avoid confusion.
Okay.
We've just looked at page 3 and we've read your lawyer's words. Did I read them accurately?
You left out a few words at the beginning, but mostly accurate. Yes, ma'am.
Do those words that I left out make a difference?
No, they didn't.
Okay. So you see that in January 2019, the lawyer that's here with you today and was representing the enterprise at the time wrote that the board, at the very least, sold property with a proper market value of $700,000 for a price of $203,000. See that?
I see that on the page. Yes, ma'am.
And what I'm asking you, and so you can see that this is the opinion expressed by your lawyer at that time,
Objection form.
Same objection.
right? I'm not making that up, am I?
Objection form.
Same objection.
Can you repeat the question, please? I'm sorry.
Do you acknowledge that at the time of this letter, Exhibit 1, the opinion expressed by your lawyer was that the board had sold property worth $700,000 for $203,000?
Objection.
Object to form.
Can I see that? I mean,
Do you acknowledge that that was the opinion expressed in the letter?
Object to form.
Objection form.
do I acknowledge that that was what the attorney said? I have a problem with the word acknowledge.
Okay, what word would you like to use?
I mean, I can see that that's what's written on the paper.
Okay. When you came on the board, why is it that you took no steps to seek relief in a situation in which your lawyer said that the board had sold property worth $700,000 for $203,000?
Objection form.
And I'm going to the extent that that inquires into the legal decisions of the board, I'm going to instruct the witness not to answer on the basis of privilege.
Based on counsel's, I can't answer.
Okay. You know that this is not a hypothetical, don't you?
Check the form.
I don't know that.
Well, the appraiser that was engaged by the board back in the end of 2018 has given adequate information from which it can be determined that this statement is accurate. Isn't that true?
Check the form.
Form.
I don't know that. I'm not an appraiser. I don't follow appraisal standards.
No, but you hired a guy who's really good at it, didn't you?
Objection
Check the form.
I didn't hire that person.
The board hired a guy in late 2018 who's really good at appraising and following those rules, didn't they?
Check the form.
Form.
I can't speak to what they did or their review of qualifications.
Do you have any reason at all to think that Bolton, who did the appraisal that we're just about to look at, is not completely qualified, experienced, and knowledgeable to perform real property valuations?
Check the form.
I'm not an expert or knowledgeable about anything to do with appraisals or appraisal standards, appraisal certifications.
You don't know anything that would suggest to you that David Bolton wasn't perfectly qualified to perform the assignment that the board gave him in late 2018, do you?
Check the form.
I can't speak to that. I mean, like I said, I don't know. I mean, I don't know anything about appraisals or qualifications. That is not anything that I have anything to do with.
Let's look at Exhibits 2 and 3.
Okay.
Do you see that Exhibit 2 is an email from from Chance Bolton, someone in David Bolton's office, sending the appraisal report out?
Yes, from Chance Bolton.
Who does it go to?
To bill@aylshirelaw.com, Jose de la Fuente.
And the Jose de la Fuente is the same guy that's here with you today, is that right?
Yes, ma'am.
Okay. Who was representing the entity at the time, is that right?
December 3rd, 2018. Yes, ma'am, I believe that he was.
Okay. You're right.
I mean, I guess. I mean, like I said, I don't have exact knowledge of when they came on, but I would presume.
Okay. And you're right, there was a fellow named Romo who was the lawyer for a while. That's the name I know. Is that a name familiar to you?
Yes, ma'am.
And he was fired abruptly. Did you know that?
Check the form.
I don't know. I don't know the details of termination, of contract renewal. I was not on the board at that time.
Well, whether you were or weren't on the board, you might still be aware of what the circumstances were under which he was disengaged.
Checked form.
I didn't have knowledge from anybody on the board at that time as to why he was fired or the proceedings or if he was fired.
Do you know now from anybody?
I don't.
Nobody's told you.
I didn't know that he was fired. I don't know that there was a board, resolution firing him. And you had another part of your question. Do I know now? I mean, I know that he's not the attorney and that they selected different attorneys at one point.
But you don't know anything about the circumstances of that. Is that right?
So I've heard different allegations about things that were brought up about Mr. Romo. I know that the one thing that I've been told by another board member was in executive session, so I don't know that I can reveal that. So I don't know that I can say anything. If it was in the executive session with another board member,
If it was
saying,
in executive session, confidential discussion of legal matters, you should not answer that
so I
question.
can't answer that question.
Okay, just so that I'm clear on timing, again, just so the record's clear. Are you talking about a time when you were on the board and you were in executive session long after Mr. Romo was gone?
Correct.
Okay.
Yeah.
I just want to be clear that I understand this is not an executive session conversation in which the board is discussing whether or not to terminate him.
Okay.
Is that right?
Yeah.
Okay.
I heard about circumstances in executive session, and I'm trying to think, I'm trying to recall to the best of my abilities if I had heard anything before I was on the board in 2018. I may have heard something around the neighborhood, but I can't recall specifically who it would have been with or, why.
How about what it was?
Huh? How
about what it was? The substance of it?
The substance of our conversation?
Right.
And I'm asking for clarification. Are you asking about prior to him being on the board and in executive session?
That's what I thought he was talking about.
Okay.
Okay, we got to reset here because I think I'm talking about different things. Before I was on the board in 2018, I heard, and I can't remember from whom, about the board firing Les Romo. I think I heard that. And I think what I heard at the time was that people suspected that the board fired Mr. Romo because he had been successful in winning the Tomo lawsuit. That's what I heard. Now, whether that's to the best of my knowledge, best of my recollection.
He had been successful in winning the lawsuit, and so they fired him? Did I hear you right?
Yes, ma'am.
Okay. Was there ever a time prior that you are aware of?
That's what I heard. Well, whether it's true or not is, I don't know. When you're not on the board and you're not part of executive session, obviously you don't know. You hear what you hear.
Well, you are aware, are you not, that there was a considerable period of time where the board of directors directed the attorneys for the organization to oppose efforts to recover the property that had been, in your words, sold.
Checked form.
Right?
Can you ask the question one more time, or say the question? There were some parts of it I couldn't.
Are you aware,
Am I aware?
prior to time you came on the board, that there was a pretty extended time when the board's attorneys were instructed to oppose any effort to recover the property?
And to the extent you're aware of the board's legal decisions or instructions to its attorneys by virtue of your position on the board as a member of the board, I'm going to instruct you not to answer on the basis of privilege. If you have any knowledge gained prior to your experience on the board about the subject matter, you may answer the question.
So, yes, before I was on the board, I heard through the neighborhood that the board, that attorneys instructed the board to oppose the lawsuit. I think it was a part of a member communication at one point.
Okay, I was really asking it the other way around.
Okay.
Did you know whether the board instructed the lawyers to oppose efforts to recover the property?
And I'm going to issue the same cautionary instruction on privilege. Again, to the extent you've gained any such information by virtue of your position as a board member privy to such attorney-client information, I instruct you not to answer. If you are privy to any such information prior to your role as a board member, you may answer.
Yeah, I'm not aware. I wasn't aware of any. I wasn't aware or privy to any instruction from the board to anybody.
I'm sorry, I wasn't aware or privy.
To any instruction by the board previous to my coming on. I think that's, I'm trying to do my best here. So did I answer? Let's try this one more time, because you're asking about a prior board.
I'm asking a member of the organization who was active enough to run for a directorship, who attended meetings, who read the letters. I'm asking that guy whether he was aware that there was a considerable period of time when the position that was taken by and on behalf of the entity was that it opposed the recovery of the property.
And I am giving you the same cautionary instruction. I object to form as well, issuing the same cautionary instruction. Again, to the extent that you have such knowledge from prior to your participation on the board, you may answer the question.
So yes, I mean, I think all members who attended board meetings, or at least the annual meeting, if I recall correctly, from 2018, was aware that, you know, the board was instructed to whatever it was that she said.
Did it not seem at best counterintuitive to you that the organization's lawyers would be seeking to prevent or oppose the recovery of the property?
Object to form.
Object to form, yes.
And again, I'm going to instruct, to the extent that this asks about what you may have been thinking or considering prior to your role as a member of the board, you may answer. If this is asking as to your thinking today, based on your membership on the board and attorney-client privilege communications and attorney work product, I'll instruct you not to answer. So that is the dividing line. You may answer if you had such belief prior to your participation on the board.
All right, so so I've got that instruction from my attorney, and if you can restate the question, and I'll try to think about best of my memory about 2018 and 2017, what I might have known.
Did you have any understanding prior to the time that you became a director as to why on earth the lawyers for the organization would be seeking to prevent the organization from recovering the property that had been sold to Martin and Friendship in 2016?
Check form.
Check form.
No.
Can you imagine a reason?
Object to form, and to the extent it asks you to speculate as to your beliefs today, and any privileged communications, I'll instruct you not to answer.
Objection form.
So I'll
Okay, just so you know, I'm not buying into the instruction that he's giving you. I'm just not complicating the record right now. I don't believe your thought processes are privileged for a second, but we'll get to that if we have to. Now, here's my question.
Okay.
Can you, as a sitting member of the board of directors today, can you envision a circumstance where it would be proper for the organization's attorneys to oppose or seek to prevent the organization from recovering the property that was sold to Martin or Friendship in 2016?
Object to form.
Objection form.
To the extent that inquires into any matter in which you've received advice from your attorneys, I'll instruct you not to answer. To the extent that you can answer that question without incorporating or revealing advice of counsel to the WSC, you may answer.
I believe I've received counsel in the past on that, so I can't answer that question.
So you don't have an opinion except for the opinion that was given by counsel?
Object to form.
Is that correct?
Object to form.
I mean, no, that's not correct.
Okay, I'm asking your opinion, not what your lawyer's opinion is. I don't really want to care about that. I want your opinion.
Object to form.
Objection form.
Regarding whether he can envision a circumstance where it would be appropriate for the entity's attorneys that are getting paid by the resources of the business enterprise to seek to prevent or oppose the organization's recovery of the property that was transferred to Martin or Friendship in 2016.
Ms. Allen, you're asking if he can envision a reason why the entity would instruct its attorneys to take a particular course of action in respect to litigation?
No, that's not what I asked him.
Well, this was a litigated matter, if I'm recalling anything at all. In fact, it's a presently litigated matter, so I can't see how you're not inquiring into something that is a core question of the actual lawsuit in which you're taking a deposition. And I'm going to instruct the witness not to answer as to legal strategies
Okay.
and any advice of counsel.
So on the advice of counsel, I'm not going to answer that question.
Again, not going to badger you, just want to make a clear record.
Yes.
You do understand that the question that I'm asking you now is a question of you as a sitting director on the board without regard to what lawyers have told you. That is my question. Now, you may still decline to answer, but I want that record to be clear.
Ms. Allen, you're asking not just about an opinion as sitting on the board and regardless of what lawyers have told you, you're asking about lawyers acting on behalf of the entity and why they would do a certain thing. I can't see how that would not encompass attorney-client communications between said attorneys and the board. So I have to instruct the witness not to answer. If you'd like to ask the question in a different way, you might be able to do so. But if you're asking about that, I have to instruct the witness not to answer on the basis of privilege.
And you and I can agree to disagree. I want you to get your statement out on the record. My record's clear, and I think that we are, if you just tell me that you're not going to answer on account of your attorney told you not to, we're going to move forward.
Okay, I'm not going to answer because my attorney told me not to.
Okay.
And Cabby, why don't you let us know when you're near a breaking point? We've been going for a little over an hour.
Anytime you want.
Okay.
No question on the table. You're free to go.
Okay. We'll just
Let's take a break.
Yeah.
Let's take a 10-minute break
Yeah.
or something.
We are off record at 11:38.